Welcome to Inherently Distinctive.
Hello, everyone, and welcome back to Inherently Distinctive with attorney Mark Goodman. Mark's a Nevada-based intellectual property attorney who helps entrepreneurs, startups, and business owners protect the brands and ideas that drive their companies forward. My name's Sean O'Connor, and today Mark and I are talking about how choosing the wrong business name can create expensive trademark disputes, branding problems, and legal headaches long after a company launches. Mark, it's good to see you.
Yeah, good to be back on. I think it's been a little bit of a time since I've hammered a recording, so it's good that we were able to set this up and get some more amazing intellectual property content out there, right?
Yeah, no, and I love this. I love this branding topic and trademarks and naming. Always difficult to do, especially these days. You know, you want the .com, you want the dot. Yeah, there's all those issues. What are some of the most common ways business owners back themselves into a trademark problem when they choose a company name?
Okay, so there's a few principles I wanted to hit on here, right? One is, and this is one of my recurring jokes, but it's good. I don't remember if I've used it on the podcast yet, but certainly with clients, right? Is that we can analogize your trade name for your business to, like, you meet somebody, right? And then you maybe go on a first date, and then you go on a second date, and then another few dates, and then you're dating steadily, and then you get engaged, and then you get married, and then next thing you know, you're married with 4 kids and a house and a 401k together with this person, right? And here's why this analogy is so important, right? Because if you're coming in the early stages of a business or potential business, it's like just dating here, right? Let's not get too overcommitted to that name right at the beginning, because it's just like you go on a first date and this person's crazy. Don't go on a second date. It's really, that's simple. And so, I'll give you some examples of how this plays out on both sides, right? A lot of times I have potential clients or clients come in here and it's like, all right, I wanted to launch this product or this business with a certain name, and they're just attached to a certain name. And then we do a search and it's like, gosh, there's some pretty large companies that has somewhat same or similar names in a similar enough industry, maybe that it could be a problem. And it's like, well, how about just get the creative juices flowing and then think of something else, and we don't even have to worry about that type of headache. On the flip side, and this happens sometimes too, I've had a client a couple of years ago come in, and she had been in business for more than 20 years with a certain name. And so for her, I didn't even promote doing a search or anything. Like, we're married with 4 kids and a 401k with this name, right? Let's file, let's get this if we can. If we have to fight tooth and nail through the system, we will. And fortunately, we were able to get it through and get it for her, right? And so what you don't want, though, is to be totally, married to somebody that turns out to be a lunatic, right? That's what you don't want. And when we're looking at what types of problems you have, there's two, I can think of right away of 2 different categories of problems, right? One problem, which is the one that most people I think about first, is, are you going to have a conflict with another mark that's out there, right? And so when you're evaluating that, there are always 2 questions that you're asking. One is, how similar or identical are the marks that the name that you have versus the name that somebody else has a trademark on already, likely, right? And then you also consider how similar or identical are the actual products or services that are being sold. Right? Because you can actually have, there are numerous cases where you have different names that are used across other industries. And this happens all the time, right? And so that's where you really just need a good evaluation of where you stand. And quite frankly, one of the things I look at, even though it's not really something that makes a difference legally, but it makes a difference in the real world, which is, let's say there's something that's maybe a little bit of a concern, but you probably could get around it. How big and powerful is the company that owns that mark? Okay. Yeah. Because if it's just somebody that's smaller or what have you, that's different than, okay, this is a multinational $100 billion revenue company that
Coca-Cola is
has
not going to
unlimited resources to try to crush you.
Yeah.
if you go after something anywhere close to what they have
Yeah.
trademark wise.
Yeah. Coca-Cola is not
And
going to let you use anything that sounds like Coca-Cola
true.
and
And
looks
I
like
don't want
the.
to make them even sound evil for doing this because they actually
No.
have to. One thing
Yeah.
that I think I've said in the podcast before is that when you have a trademark, if you don't take adequate steps to enforce your
No.
trademark, you
You
actually
got to
can
protect
lose
it.
it.
Yeah.
So they have to kind of,
Yeah.
the law forces them to be mean sometimes.
Yeah.
So that's another thing to be looking at. The second thing to really be thinking about when it comes to selecting a trade name is how descriptive is your trade name, right? And this is tough because from a business perspective, many business owners want to have a trade name that describes or at least suggests what the company sells, right? That may be better for search engine optimization, that customer and client recognition, right? So it could be more important, honestly, than me as your trademark lawyer saying, no, that's not what we want. Because from a trademark point of view, the best names are as far away as we can get from describing anything about what the product is. And there's like a spectrum.
So if I came to you and said, hey, I want to be Sean's window washing service because people are going to be searching for window washing services in, whatever city I'm in, that might be good on the SEO side of things, but textbook trademark attorney is going to be like, that's a little too generic.
Is too generic. And now at least you have the phrase Sean's in there, right?
Yeah.
So that's something, right? And a lot of people name Sean, somewhat common name.
Yeah.
But at least you'd have a trademarkable name potentially. Here's where it can get even worse though. It's like example I often use. It's like, let's say we open up a coffee shop and we just call it the coffee shop.
Yeah.
Awesome.
Hey.
You can do that. You can operate generically if you want, but you can't get a trademark and sue people for calling a coffee shop, for example, right? And sometimes people will think they can do something very cool. Now, of course, almost everyone understands that intuitively, right?
Yeah.
But when you drop away from that, there's a spectrum, right? Hot and fresh coffee. Again, that describes an inherent characteristic of that product.
Yeah.
So it's going to be pretty much impossible to get a trademark on that.
Got it.
And sometimes the sweet spot is something that's suggestive, right? So I've used the example like In-N-Out Burger, right? Is kind of, that's okay. That suggests something about what they do, that you get in, you get your burger, you get out,
Right.
but it doesn't really describe it. So that's a stronger mark, right? And there's often there can be huge arguments that we've had with the trademark office and the board about whether a particular mark is descriptive or suggestive, right?
Yeah.
And the legal consequences is if it's descriptive, you have a much more difficult time getting the mark. You would have to show, you can still do it, but you'd have to show some serious level of marketing and customer recognition in the market, actual evidence of it, right?
Right.
You have to present that to the trademark office and they would evaluate that. That's quite a bit of a hassle, right? Which if you're already further along, like my other client, right, and you've already been doing it this way, sure, let's do that and see if we can get it. And maybe it's even more valuable because you can get a relatively either generic descriptive name, right? It's amazing how some big companies have done this, right? Example I think of is Holiday Inn, right? If I were to apply for that now, we would not get Holiday Inn. The trademark office would reject us. They'd say, holiday, well, you're going on holidays. That's an inherent characteristic of going to a hotel or inn or motel, whatever you're doing. No, but because they've had decades of customer recognition, that can be an exception, right?
Yeah, ton of equity.
But if you're starting something out, you don't want to have to jump over that hurdle, right? So then the next level out is an arbitrary mark, right? Because there's sort of a relativity. It's almost like trademark theory of relativity here, right? Because all of this is relative to what you're selling. So the trade name Apple, for instance, is an outstanding trade name for computers, smartphones, tablets, streaming music services, right? Awesome, right? But if the Apple computer company decided, well, we're going to really leverage our brand here, let's buy a bunch of orchards and sell apples. Again, they could do that, but you can't like sue people for calling an apple, right? So in that field, they would have no trademark rights. And the highest level is what is called a fanciful mark. In other words, something that's not even any kind of word, just some made up thing, right? The pharmaceutical industry is best at this. I feel like they probably employ teams of full-time stoners to just sit around coming up with these names, Rinvoq and Dupixent and Ozempic and Wegovy and all these kinds of things, right? And these are great trade names. And I don't know if this is trademark driven or if they just think they want to have everything sound like scientific and stuff, maybe a little bit of both. But that's actually the ideal mark. So if you can get creative and come up with something that actually maybe it has a little bit of suggestivity to you, but doesn't have any real linguistic meaning in any kind of dictionary, that's the strongest way to get a trademark. But again, you got to balance that against, well, is that the best thing for your business? And what I always do is just describe where we are in terms of trademarks so that a business person can put that on the scale and figure out what he or she wants to do.
Yeah, the made up names for sure, right? Part of that, I think, is driven by the fact that there's very few words available these days.
Yeah, it is. It is hard. Like there are so many trademarks out there, and it makes sense. Every business really should have a trademark. So think how many thousands and thousands of businesses there are in the United States, and yeah, every time you put any kind of word in there into the trademark search system, for instance, you will come up with a whole bunch of stuff.
Well, I'm wondering too if, can businesses still run into trademark conflicts even if they change the spelling of a word or add extra words or, a slightly different variation of a name? Does any of that pass muster? Or does it depend on the trade category or how?
Generally speaking, those small changes aren't going to help you at all, right?
Okay.
It depends on, and you could evaluate different ones differently, right? So for instance,
I mean, it almost points to the fact that there's an issue.
yeah, because trademark, and this is both good and bad here for you when you're thinking about this, is that trademark infringement has more scope than just literal infringement, right? If we open up a coffee shop and we call it Starbucks singular, we're getting sued, okay?
Oh, yeah.
Right? If we call it Harbucks, we're also getting sued. You'd have maybe a non-frivolous defense in court, but don't do that, right? But as you walk away, again, there's so little things like just changing it to a foreign language actually doesn't help. Except sometimes you can fool the trademark office because you're supposed to tell them, right? See, if it means something in a foreign language.
Yeah.
So don't mess around with that either, right? But
right.
But even if you add a one letter or you have a phonetic misspelling, like using a K instead of a C, right?
yeah.
Because what matters is the commercial impression of the mark, right? Which is, what would an average consumer associate?
Yeah, regardless of spelling. When I hear quick copy, I hear, the sound. Oh yeah, sure, you're spelling it with a K, but it's Q-U-I, whatever it might be. And
right, or adding like a silent letter at the end or a dash between the words instead of two words. That stuff is now okay. So, but this brings up another point that I run into a lot, though, which is that even though first of all, and the reason why that is good is because it would kind of suck if you got this trademark and someone could change one letter and get around you, right? So even though that makes it harder to get through the system to get your trademark, it's worth it because once you get your trademark, it has actual value there, right?
I wanted to ask you about, you were talking about changing one letter versus another. Internet, huge consideration for any business these days, right? And, that is a place where changing one letter makes a total difference in terms of the website I go to, et cetera. And, or .com versus .org, .law. There's all these new domains.
True, and that's just something to understand the differences, because with something like a URL, it's just a registration system, right? So if I have the website markgoodman.com, you could come up with markgoodman123.com and get that URL, and that's just the way that system works, right? Whereas trademark, we're talking about what we're doing big pictures, we want to prevent consumer confusion in the marketplace. So it makes sense to have more scope than just that. If
Right.
you could just change one thing, it would just wouldn't the whole thing would collapse. It'd be worthless, I think, because anyone could easily get around it. Other systems, like people are familiar with corporate name registrations, right? So when you say form an LLC or corporation, that tends to work closer to the registration type system as well, right? Where if I have Mark Goodman LLC and you have Mark Goodman 1, 2, 3, 4 LLC, you can generally do that. Although I've heard some states police it a little, but for the most part, you can generally, as long as those characters are available, you can get it. But that has nothing to do with your position as a brand in the marketplace and your trademark protection of that brand. But it is also important to know, some people assume that the name of their company has to be the same as the trademark. It obviously does not, right? So Alphabet is the company that owns Google, right? For instance, right? So now, a lot of times when you're starting a small business, it's easier if you do make it the same. And of course, you may have multiple products and services, and each of those could have a trademark. So obviously, it doesn't have to match up that way.
Right.
And now I remember what I was going to bring up before. When you talk about this exactitude of an exact name versus a minor modification, although that is not important in the terms of whether there's a trademark conflict or whether there's infringement, that is important in one sense. When we file for a trademark, we will have to show the trademark office our real branding in the marketplace, showing that we're using it in commerce, selling a product. And what we apply for has to match up exactly with what we show them. So, and this actually runs into a problem, because sometimes I had this just the other day, right? We had it was a two-word trademark, right? And we applied for, because this is what the client gave me in the intake, right? Is the two words were hyphenated, right? So it was a word 1 hyphen word 2, right? And then when all the branding that they showed me later, when we went to show we're actually selling, was like 2 words without the hyphen, at least in one of the product categories, and the other product category was okay. So we just had to fix this, right? And it just creates a little bit of hassle, but that's just good to understand, because, and understandably, when people are in a newer business, they're just trying things. Oh, let's move this around. This happens a lot with logos, right? You have a logo and the name is to the right of it. And then we end up using it later, the name is underneath the logo. But the trademark office doesn't want that. They want it to match up. And
No, you gotta have different versions, and yeah, there's so many moving parts, and
that's true, even though even though those marks would conflict legally. But when I understand what and it's interesting about this too, is that early on in my career, right? So before about 2013 or so, right? I'm dating myself here. But back then, the trademark office didn't seem to care about this. So there must have been some change in case law precedent policy over there around 2012, 13, 14, that range. After that, they started kicking stuff back. Goodman, it doesn't match exactly. You never cared about this before? I've done 6. Okay. So now it's our policy. We make sure to tighten that up.
listen, we're about out of time. I want to ask you one quick question. For someone out there launching a business, right now, what are a couple of quick things that they should focus on to make sure that, hey, give them the best chance that they're building a brand name they can actually keep long term? And again, just 1 minute.
Yeah, I think we hit on both of them, but it's good to summarize in broad strokes. Number one, let's be creative about this name.
Okay.
Right. Let's not just either just throw your name on it, or in general, right?
Yeah.
Or just throw it, describe basically what we're doing,
Yep.
right? So creativity on the name, and then as well, just do a search and be careful, especially if you're dealing with a large company.
Yeah. Well, listen, man, super engaging and interesting, and this is just underlines the fact why you need a good attorney to navigate some of this. And I look forward to to future conversations, Mark. Thanks for your time and expertise.
Absolutely. It was a thrill.
That's it for today's episode of Inherently Distinctive with attorney Mark Goodman. To learn more about protecting your ideas, inventions, and brands, visit Mark's website, goodmanlawnevada.com. Thanks for listening, and don't forget to leave a review or a thumbs up or subscribe to the show so you don't miss an episode, or share a link with someone in your world who's maybe starting a new business. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.